I think, as you mentioned in your opening statement, it raises a very fundamental issue, I think, before Congress, and I think that fundamental issue is when Congress passes a statute that says it's unlawful to do something because of race, sex, national origin, in this case, age, how much discrimination is the Congress willing to allow? How much discrimination does that type of statute tolerate? And I think Congress thought they answered that question. I know we thought you answered that question, and the answer was pretty straightforward: none. These laws don't tolerate some level of allowable discrimination, but unfortunately the Gross decision changed all that. And the bill that you have before you is a balanced response to Gross. It is a fair response to Gross. And indeed, it's a conservative response to Gross, and I can talk more about why I believe that as we move forward. Now, my colleague indicates that it will do nothing to help workers. And I think his comment was, it's a moral victory, nothing more. I think you want to ask Mr. Gross about that. Because under the very standard this bill proposes, Mr. Gross won. He would win again under that standard because the jury found that age was a motivating factor and that the employer could not prove that they would have taken the same action anyhow, that it was in fact a violation of the law, and the jury awarded him $46,000. I don't believe he views that as just a moral victory. The law has teeth, it has meaning. Now, what did the Gross decision really do? Number one, it ignored interpretations of every Circuit Court of Appeals that had addressed this decision since Price Waterhouse was handed down in 1989. It was a consistent view of all the courts that there was a motivating factor causation standard within the ADEA. But the court ignored that. The Supreme Court ignored that and said, no, the law, the age law, tolerates more discrimination than Title VII tolerates, unless you, Congress, make it very, very, very clear that you're not going to tolerate any type of discrimination like that. So number one, the question is, this is for Congress to fix, and in fact, Justice Thomas, in his opinion, says, this is Congress's issue. If you want us to protect, then you need to tell us explicitly. Two, it has caused havoc in the courts. One, it's called into question the McDonnell-Douglas standard that has been applied for literally decades in the age case. Courts are struggling because of what the Supreme Court said. More importantly, it is called into question what is the appropriate standard of proof under a lot of other statutes, not just the ADEA. The Seventh Circuit says it applies to the ADA because their interpretation of Gross is unless you, Congress, provide these magic words, the mixed motive type of analysis, then it is but for causation. And so it applies to any statute that is out there. And in fact, employers are arguing it applies to every statute that's out there that do not have these words. That is the reason I say that the bill is a measured response. It reinstates the law to what it was prior to Gross. It makes it clear that when Congress says you shouldn't consider something, hey, you should not consider something. That is a violation of the law. It provides the employers with the ability to say, if I would have done that anyhow, they can limit their liability, so it is a measured response, and it does not tolerate some level of discrimination. Rather, it sends the message that I think you all sent since 1991 and before, that when we pass discrimination law, we are not going to allow some level of discrimination or a little bit of discrimination, that we are here to combat all discrimination. And I'm prepared to answer any questions on the bill or any follow-up you may have. Thank you.